Hello and welcome to The Conversation. My name is Shannon Taylor. I'm the Executive Director of Blacks and Jews in Conversation. And as you can see, our distinguished guest today is the Honorable Eileen Nadelson from the Criminal Court in Manhattan and Brooklyn. She has been in both courts. She first thought I was going to leave out Kings County, but no, I would never leave out Kings County. Dear to my heart, dear to our hearts. Everything happens in Brooklyn and then spills over to Manhattan. I hate to tell you this. And I remember when Honorable Nadelson joined us in Kings County and then as well in of course, New York County, because I was already in the court system. And Blacks and Jews in Conversation had been functioning for many years. We are already, I would say, 15 years. It's our 15th anniversary. And we had developed from Blacks and Jews to not just Blacks and Jews. And now we had competition because Honorable Nadelson herself, by herself, receives students and goes out to the students and receives adults and goes out to the adults and does programs in the bar associations and tells people how to prepare for court and how to prepare for small claims, all on her own without us. So I figured the best way to meet this challenge head on is to invite her right onto this program and make her part of us rather than go head to head. And so here you are, Honorable Eileen Nadelson and Blacks and Jews in Conversation together at last. It's only taken a number of years to form this initiative. She had a calendar that overflowed. And I said, enough with this calendar, leave it for the time being, and come join and meet our audience here on MNN and our commercial-free public access network, and reintroduce yourself to the Manhattan crowd.
Thank you, Shannon. It's great to be here, and I do believe in amalgamating the forces. So here I am, and I'm willing to talk about what I do, because I know that the organization with you does a lot of good as well. So I don't know, what do you want to know, except that I do the same similar things that your organization does. So I go out to the public. I think the public should know what's going on, and the public usually doesn't know what's going on. The courts, particularly the courts, the legal system is very arcane, it's very secretive sometimes, it's very complex. It's hard to maneuver in the court system. So what I like to do is I like to go out and talk to the people and say, if this happens, be prepared for that, be prepared for this, know what you have to do, know what you have to say. Well, I can't really tell anybody, I'm not allowed to give advice because I'm a judge, so I can't give you advice and counsel you as if I were still an attorney. But I can tell the public that if you get arrested, this is what you can expect. And if you are bringing a case, if you're in civil court, where I sat for also a number of years, I've been in criminal court for 2.5 years, but before that I sat in civil court for about 4.5 years. So I've had my fair share of both courts, and I like the public to know what's going on. And it's very, as a matter of fact, the court system is interested in making it accessible. It's just that we sometimes just don't know how to reach the public. And if you could figure out a way to talk to us or to get to speak to us and let us know what you want to know, hey, I'm willing to let you in on whatever you need to know in the court. It's not a secret as far as I'm concerned, but the public sometimes is afraid to come and talk to us. So whenever you want to talk to me, just let me know, and I'll be here talking to you, telling you what to expect and how to prepare yourself.
Well, that's just what you're doing now. You're addressing the public on our airwaves, and we initiated, I would say, with Judge Thompson, Judge Hornblast, Judge Douglas, Judge Figueroa, Judge Tomei, Judge Jim Brandt, Judge Doris Lynn Cohen.
Wow.
The list goes on and on under the auspices of Chief Judge Kay. We initiated judges leaving the bench without their robes, with their robes, what have you, whatever was more comfortable, and going into the public. And we've done programs of all types for many years, some along the lines that you've done.
Oh, you mean you never told me that you were doing it? I just did it on my own. Is that the idea?
Yes,
I could have been talking to you from the beginning.
That's right. But you see that I was absorbed in public relations and in press, and I noticed that next to my picture in the newspaper and next to the pictures of our members was your picture, and I kept seeing a competition there in the press, in the Eagle and in the news and elsewhere.
Right.
I would see, look at this, and I got to keep up, you know, and other people were saying, Lord, she's outdoing you over there. So.
Well, I got to tell you, this sounds a little bit like bragging, so forgive me for that. But I really do, my mission, if you will, I really do believe that people need to have the knowledge, because, as my father used to say, knowledge really is power. If you know what's going on, you will be able to handle your stuff. If you know what's going on, you can handle it. It's complicated. You don't want to be in front of a judge without a lawyer. I suggest you don't do that. But there are some things that, especially in civil court, when I was in civil court, we have small claims. Many people come without a lawyer. But you'd be surprised how they don't know what to do. They don't know what to say. So all you have to do is just figure out how you're supposed to approach the judge, and everything rolls very smoothly from there. It's really not as difficult as you think, and we should have more seminars, Shannon. We should have more conferences open to the public so that they could just come in and sit down for like an hour. It doesn't take more than that. An hour and a half maybe, with questions and answers, and just ask what you need to know in the court, and we could tell you. And you will be able to go into court on a much higher level of understanding. And that's all there is to it, and I am a great believer in that. I think people should know what to do when they're at court. So that's why I'm out there talking to the public all the time, because I want them to know what's going on.
Well, I give you credit. You do a lot more of something than we have. We've pioneered conversations and introducing people and discussing hate crimes and stimulating discussing and getting certain legislation analyzed. But you actually get into the nuts and bolts. You get into the list as long. How to prepare yourself for court, appearing pro se, developing real estate, making your own contracts, and then getting the mechanisms ready for defending yourself, for getting a lawyer. You've gone before the bar associations. You've worked with our old friend Barry Cammons. I'm reading this because even though my memory has always served me, it's very developed. And for all of that, you have to prepare yourself, because you're representing all of this before people who are unskilled and unknowledgeable, and then they're going to hold you to an account. And you don't have to do that. You're on the bench already. They are supposed to come to you and petition you, but you're now empowering them to essentially challenge you and to challenge other judges. That's right. What you're giving them, the ammunition that they should be finding on their own. Exactly. You're essentially stocking their cannon.
Exactly. And I tell you the truth, I did this after I got on the bench, because when I was in practice, I used to educate the public also about contracts and preparing for court and stuff like that, if they didn't have a lawyer. But when I got on the bench, I realized how few people knew what was going on. I mean, they were getting slaughtered as they came up before the judge. And we're not allowed to tell anybody. The judge cannot help a litigant. So if you come unprepared, you lose. That's what it comes down to. And a lot of people really had cases that deserve to have some merit to it, deserve to have some rationale to it, or deserve to have some decision in its favor. But a lot of them were losing because they just weren't prepared. So I thought, oh, wow, I got to get out there and just talk to these people and say, this is what you need to know before you come to court, because if you come to court unprepared, you lose. That's the way it goes. So if you come prepared, you can win. And if you have a case, then you should win. If you have a good case.
Nothing upsets a person more than thinking he has merit and he has right, and he can't implement it and he can't satisfy it, and he or she goes out saying, what went wrong? And then they blame the court, and they blame the system, they blame the society, and it's pent-up frustration, and it finds a way out either in family or in business or in social relations. It's just a strain. It finds a way out somewhere, and it's not good.
Right.
And who wants the party that is not just, the party that doesn't deserve to have the victory, who needs that party to have victory? Because then you bring about injustice.
Or get away with something. The party who may not deserve to win is winning now, or doesn't win, he just doesn't lose. He gets away with it because you're not prepared and because you can't make your case before the judge. He just gets away with it. And that's what happens.
Where do we find that the most? In Charles Dickens and English literature. You go back, the stories are replete with how you had this poor person. I remember W.C. Fields played the character of Micawber, and he says if you earn, let's say, $50, and you spend $49, you have happiness. But if you earn $50 and you spend $51, you have a life of unhappiness. And if you have the wrong case with the wrong lawyer, you have misery. And that's what happens simply if you have the wrong tools. And who gets blamed? The legal profession.
Exactly.
And we're not to be blamed, because who's to be blamed? Ignorance.
Yeah.
So is it our job to stem ignorance? You were a teacher before you became a judge. You taught English, you taught math. How much of the role that you rightfully put upon yourself and assume is due to your previous role as a teacher? Many actors, very successful actors, entertainers, judges, they were all teachers in the past.
I guess a lot has to do with that. When you're a teacher first, you just have an inclination to teach people. So I always wanted people to learn and find out what was going on. The only place there's a caveat here, that you can't do this that much in criminal court. I'm in criminal court now, which, by the way, is fascinating. I did civil court, but criminal court is really fascinating for me. And you can't really do that much on your own in criminal court. But you do need to know what's going on so that you can have a true conversation with your lawyer. Many defendants that now appear before me, they haven't got a clue what's going on in the courtroom. I mean, the lawyer, yak, and you could see this blank look on the defendant's face, like he doesn't know what they're saying or why they're saying it. If you knew what was going on in the courtroom, and you can learn this, truly you can, then you can actually have a conversation with your lawyer to say, well, maybe we should ask about this, or maybe I should know about this, and he does the talking for you. Do not do your own talking in criminal court, because you don't know the lingo, you don't know the procedures, and it could be dangerous. And also in criminal court, whatever you say is held against you, so to speak. It's on the record. In civil court, it's not so much on the record, but in criminal court it is. So we don't like you to speak in criminal court. You have to sort of lean over, and you say psst, psst, to your lawyer, and then tell your lawyer what you think he should ask, or tell your lawyer what you think you should know. And you could do that in the court. We stop. If we see a defendant want to talk to his lawyer, we stop. We don't go right past you. So it's all a matter of just understanding what's happening, and then you can have a conversation with your lawyer and get in on the act. And that's how we do it in criminal court.
Does it look bad if you want to pause and consult with your lawyer? Does it look suspicious in any way?
No.
Does it upset the motion of the proceedings?
No. Where the court understands that you're the one who is on the line. You're the one that is the one that's being accused of some crime. We stop the procedures. You have all the opportunity you want to discuss what's going on in the process. We never step over the defendant. And if they do, by the way, and sometimes this happens because things go very fast at criminal court, you don't know what's going on. If it does get by you, then stop your attorney and say, I don't understand what just happened. You can actually stop the procedure and say, what just happened? And then the court will explain it. I mean, judges will explain it, or the lawyer will explain it. You're entitled to know what's going on. It's your life that's on the line. I mean, give me a break. We want to make sure you know what's happening all the time.
Now, over the years, our organizations have brought students into the courts, criminal, civil, to see the judges, to meet with the judges, to discuss things with the judges.
Right.
But we have not brought them in to see actual proceedings. I understand that you've gone to the schools, we have as well,
Right.
of all ages, to introduce yourself to the students. So we've found a very positive reaction almost all the time, because they don't have this opportunity. They don't have an opportunity
That's
to
true.
see
That's
and meet
true.
and talk with judges.
Right.
Do you find that it would be helpful for people to actually witness proceedings, or that because of the acoustics, because there's no microphone, because they move rather swiftly, because they don't have a background, or that would not serve a purpose?
It's perfectly appropriate and very educational. Sometimes some college students come in, not high schools. The high schools, usually we go to them because they have mock trials or, some kind of facsimile proceeding in their own schools. But they don't often come to the courtroom. But believe me, if they came to the courtroom, you could really get an education. It's a wonderful education. As a matter of fact, I once wanted to propose, maybe you're the one to talk to, Shannon. I always wanted to propose that it's very tricky to get cameras in the criminal court because you have a lot of people that you have to get through. Defendants may not want to be televised. There are witnesses that may not want to be televised. You have to get everybody's permission to televise in a criminal court. It's not that, quickie, let's bring a camera into the courtroom. And so far they're not permitted because anybody could say no. And that's why we don't want cameras in the courtroom. They're thinking of passing legislation against that, which means that we could block out some faces of people who don't want to be on the media. But right now you can't do that without people's permission. But I wanted to have sort of like a program, like Judge Judy, only it would be for criminal court, and it would be the okay of the defendants. Defendants would come before the judge, a real judge, and real defendants, and you'd have real people at the court, and they would agree to be televised, and you would see exactly what the case is about. And they would have to agree to this, of course, that's the thing. And arraignments, if you come to arraignments is when the first time you come before a judge, you've been arrested, and now it's the first time before the judge, and the judge is sort of saying, this is what you're accused of, how do you plead? That would be a very educational time, because at that point, a lot of talking between the lawyers and the defendants and the judge is going on. Like, judge, this is not right with the arrest, or something happened that wasn't appropriate, or we shouldn't set bail because this is the reason, this is the reason, this is the reason. So you really get to see what it's like to be in criminal court when you come to arraignments, the first step in criminal court. And if defendants would let you do that, we could actually do arraignments on television, have defendants brought up and be arraigned, which means they're now before the judge, and we decide whether we should set bail or whether they should be released or whether they're, what they've been accused of. And you would get a whole education on what the court's like, just on that introductory court proceeding. So I think it would be a great learning experience, but here's the catch. You have to have people's permission because you can't televise defendants unless they want to be televised. So it would have to be an okay, The judge can agree to it, the lawyers can agree to it, but the defendants have to agree to it. That's what's holding it back.
With the 92nd Street Y and independently, and with the court system that runs wonderfully organized tours through David Bookstaver's office, from the inception of our organization, I put together tours of arraignments.
Really?
Yes, we had, but not with cameras. Tours
tours.
On the catalog of the 92nd Street Y, and they pushed me to do this twice, 3 times, 4 times a year. Okay. It involved more work than most any other tour. It was the most popular thing that Y had for tours.
Was it really? Hot dog, my idea was right.
Right on target. I had Mel Sachs, or I had other well-known defense counsel for the defense. Robert Morgenthal's office was right on board. District Attorney Hines' office was right on board.
And you had defendants to come before the cameras?
No, we didn't use cameras. We didn't use cameras.
Gotcha.
And we had the prosecutor. We had from homicide and Mel in Manhattan, and we had Judge Koropnik in Brooklyn, and Hines' office representing the prosecutor, and Koropnik was on the bench, and we had a tour tours of the pens and the tombs.
Really?
And we had the warden's office involved. We did it for Rikers Island. And I got permission from the commissioner.
Who was on the tour? Were they youngsters?
They
were
were
adults?
from the 92nd Street Y, 50 people, 60 people, the maximum that could fit. And I had musicians come to Rikers. I had professional drummers and trumpets and singers and comedians. And we entertained 400 people at Rikers. And we did it through the corrections department. And we showed what happens before, during, after. And the whole, we called it the Geschichte in Jew. The whole story is let out there. And it was so much, at the holiday time we did it for Rikers. And we brought them a holiday cheer with a comedy and a musical show. But otherwise we did 4 times a year for the arraignments from soup to nuts.
Is that right?
And with Judge
believe this.
Judge
That's so
Murphy.
great.
We did every supervising judge at the time in Manhattan and in Brooklyn, and then the Y did away with its tours. And so I was relieved of this tremendous burden, because to me it was a tremendous burden to organize. It requires someone of your skill to see. The wonderful thing about the courts is, and about judges like yourself, is there's no burden for you. That you take on these tasks and you love to do them.
Right, yeah.
And the more, that's why you're a judge. That's why you're a state judge, is because the more you like to do. And for me, there's a limit. And there was always a limit, dealing with the public and dealing with all these divisions and all this. To coordinate them all, you have to coordinate prosecution and defense and corrections and get permission of all these different departments. And they were 100% forthcoming. But to put it all together requires a lot of
Why can't you do this in the courts won't let you do that. That's the problem. You see, you can't do it in the courts yet, because the courts won't let the cameras. They will let tours in, though. Why couldn't we do it at arraignments?
You can
reinstitute
it on your own. Yes, you can reinstitute it on your own.
Is that right?
You can bring back the arraignment tour on your own.
I think that would be great.
I bow out.
I think that would be great.
It's too much
You give me
for
the information, I will put it before the court.
I had flyers. I had flyers and circulars and press, and we advertised. It was noted in the Law Journal, was loaded in the Daily News, in the New York Times. They reviewed it, and they gave it great accreditation, and it was one of our best features. And I was left dripping sweat from the whole thing.
And people actually came down to see this.
And the best reviews. The best that people wrote the 92nd Street Y, this was fabulous.
Very exciting.
And so a person like you could take it up.
Yeah.
If you teach real estate and you teach contracts and you work with the Present City Barbaric Caymans, this will be nothing for you. Go right ahead.
I think I'm going to take on the challenge, Shannon. I think I'm going to see what I could do about this. I'm going to see if we could have tours coming into arraignments. Be perfect. By the way, it's sort of like watching a sitcom sometimes, because some of it can be pretty funny from what you hear. And it's also sort of like watching a television program. If you watch this, it's very entertaining. How can I tell you? It could be very saddening, and it could be very entertaining. So I think people, it's like coming down to watch a show. It really is like coming down to watch a show.
The courts are cooperative. Divisions are cooperative, but you must get the permission of each division separately, and you must improve the acoustics. The acoustics are awful, and you must mic up, because otherwise you sit in the audience and you do not know what is being whispered to the court from the defense, from assigned counsel.
It should be on a microphone. It's on a
The
microphone.
microphones are not heard in the audience unless you set it up in advance. That this is coming from the world of entertainment. These are things that I knew about in advance.
No, we have microphones that the people in the audience are supposed to hear what's going on. Arraignments are open to the public, which means it shouldn't be difficult for anybody to come in. I just never thought about arranging a tour, but that's very good. But our microphones are geared so that the audience here's what's going on, because it's public knowledge. It's open to public knowledge. Anything that goes on in the courts is open for public knowledge. So you're supposed to hear what's going on with the judge and the defendants and the lawyers. And our microphone is supposed to project.
It was done with Judge Oliver, with Judge Miller, across the board through 12 years we did this.
No, I can't believe it. This is great, Jen. This is great. I'll tell you, I never thought about that. Just have tourists come in and people can see what's going on. That's another way to educate the public.
And
Definitely.
unfortunately, the 92nd Y stopped its tour department. We always found partners. I always look for partners, existing groups that would do part of the work to join forces to us. We have no budget. We don't do much of any fundraising, but we're one of the few groups that have courts and judges available to us.
Would you tell me some of those organizations so I can reach out?
Well, we work together. It's an honor to work together, and I'll be happy to do it. I've done it for our entire, for my entire association with the courts. I've always shared. I never believe in keeping the public, in the dark. In the dark. Right. This is something that's possessive. Right. This is something that the courts share, and we share. Right. Listen, the courts announce everything they have on the web pages to the whole public to take advantage of the whole thing.
That's true. That's true. Yeah.
Now this happens to be. I wanted to ask you directly. What's going on in your court right now? What's of excitement there immediately?
Excitement right now? I don't know. It's always exciting to me. We have cases. If you came to see, the cases generally about drugs, because that's what seems to be prevalent out there. The cases are also about assault, so like people are beating each other up. So cases are about domestic violence. So what you're going to see generally, now we do see murders sometimes, but that's not prevalent, thank God. But you will see the general criminal behavior sort of focusing on drugs, assaults, and I guess drugs and assaults. That's the major ones. And of course there's some juvenile activity. Not a lot, but there's enough juvenile activity to make you nervous. And I got to tell you one thing that's happening also that we should be concerned about. Guns are becoming more and more accessible. I see a lot of cases now where they're using weapons. And if you don't think that's scary, I mean, it used to be where people but they would sort of beat each other up because they got angry at each other. But now they have weapons. They're using weapons against each other. That's pretty scary. So I think we have something to worry about when it comes to that. I'm a great believer in doing away with weapons. I think if you're going to get mad at somebody, you should use your mouth and keep your hands in your pocket. But if you can't keep your hands in your pocket, at least you're not stepping into, murder, because that's a pretty serious crime when you do that. And you can't take that back. You could take back a black eye, and you could take back a bruise on your arm, but you can't take back murder. That's when it's over, it's over. And there's one other thing that seems to be cropping up a lot is drinking and driving. So people are starting to drink and drive. That makes me crazy. I notice that a lot more, and I am particularly adamantly against that. So when I get a defendant that's been drinking and driving, I let him have it, or her have it. Like, don't you dare drink and drive, and if you have one drink, call a cab, and it's just too much of a risk to put somebody at risk like that, to put somebody's life at risk. But people are doing that, drinking and driving. So that's pretty much what's going on. I mean, I can't think of any particular case that I could tell you about. That I can't discuss it anyway. If I'm in the middle of a case, we're not allowed to discuss it.
No, I know that. So I want to thank you very much for coming on. And people can reach you at 120 Skirmerhorn in Kings County, the criminal court. Right. Honorable Eileen Nadelson, I just want to note that we're going on to the Apollo Theater tonight. It's live. The Council for Israel is having a hip-hop violinist and rap artist and so on, celebrating the 60th anniversary of Israel. And our organization is being brought in by the America-Israel Friendship League, our sponsor, and it's also the celebration of the veterans of Israel and Independence War in Israel. Thank you.
Thanks.